and how that doesn't demonstrate an equal protection violation when I am 100% unequivocally guaranteed equal protection under the law.
Okay,
I wouldn't know what
let me stop you 1 minute about your argument on the cherry picking. You've done a lot of work on it, I can tell. I've been the magistrate here for 18 years. Before that, I was a judge for another 20 years in Volusia County. And almost every other time I come here, someone will say, you're treating me like you're not treating this person. There are other violations that go on, and you should not be doing things to me because you're not doing things to these other people. So I say to them, can you refer me to a case that went up to the district court or the circuit court or something to say that this argument of cherry picking is substantiated? And I haven't got very much, to tell you the truth. I have to comb my mind into this particular one. Now, if you don't win in this case and you appeal it to the circuit court and they substantiate that argument of cherry picking, I would be most interested to know about it. Is your argument for this particular one going to be the same in the other two?
Some.
Yeah.
As far as, I don't know if I'm cutting you off, Your Honor. I had other things to say about the fence issue besides the equal protection issue.
Okay, well, you understand that I'm not buying the cherry picking argument.
I still have a right to place it on the record because
you do have a right, but I have a right to continue with my hearing, and when I think I've heard all that I want to hear on a particular item, I can tell you that to go on to something else. So let's go on to another one.
Good morning, ladies and gentlemen. This is the City of Ormond Beach Special Magistrate hearing for February the 27th, 2023. I'm Senior Judge Pope Hammer, who's been appointed as a Special Magistrate for the City of Ormond Beach. And I'll tell you how we will conduct the hearing, and then we will begin. I will call the cases. Today we have 4 cases. One case is the same respondent for 3 cases. We have a 4th case, which I think will be fairly quick under old business number 4, and I'm going to call that first. We have 3 cases with the same respondent, and do you desire to take these individually?
I would like to do all of 3 before the respondent gives her,
Okay.
like, up to recommendation.
Okay.
For each.
Are you the respondent?
Yes, I am, Your Honor.
Is that okay with Your Honor?
Yeah, it's okay. Is that to make a record of what he's doing there for appeal purposes?
Yes, Your Honor.
Yeah, okay.
Your Honor. I realize you haven't formally called the case just yet. Once you've done that, but before we go into any factual presentation, I have a matter of law to bring up with you that would precede that.
Well, that's fine for you to have a matter of law, but I would prefer to do it this way. I will call on the city for their testimony as why the violation occurred. Then you may respond to that, and then you can give me any case law you want to at that time. That's the way I'd like to conduct it.
I understand that, Your Honor. I guess my concern is, first of all, that I was handed all the evidence about 9:58 this morning, and the statute clearly requires fundamental due process. I also have received no confirmation from them that they have submitted to you the materials that I submitted ahead of time. And besides all of that, in my materials, I mentioned that this case was actually brought illegally because Florida Statute 70.45 required them to issue a written response to me as to why they feel that I have caused a harm by these supposed violations, and how their proposed regulation is proportionate to the supposed harm that I've caused. Before they can continue with that, they are legally required to submit an answer in writing to me, unless they submit in writing to me something saying that they're no longer going to be pursuing that. Instead, they've totally ignored that. So this proceeding was actually commenced illegally. That's why I wanted to bring that up before they had the chance to continue with this, because it violates due
I will allow
process.
you to do that. We're at a limit for time. There are other matters that I will do this afternoon, and so I have to conduct the hearing the way that I think that it should be conducted. As far as the material which you had, that it was delivered to me Saturday about 2:30, and I have reviewed all that.
Okay, thank you, Your Honor.
Now, so specifically, you feel the hearing is not appropriate to be brought. Is that what it is?
That's one of my concerns, yes, Your Honor. That would be the concern that I feel it would need to be addressed at the onset of the hearing rather than bringing that up in the middle.
Yeah, okay. We will proceed with you.
Do you want me to, I didn't know if you officially called it yet, so I was just waiting.
Yeah, I'll call it. I think I already spoke, but I'll call it. Case number 22-11223, parcel 4223020601330. Michael Henry and Katherine Henry, P.O. Box 333, Ormond Beach, Florida. Location of violation 33 Cypress Circle, Ormond Beach, Florida. The alleged violation is no building permit issued as stated in the Land Development Code, Chapter 2, Article 3, Section 250N1A, fence installed without permit. The second case is case 22-112-246, parcel 422303060130. Michael Henry and Katherine Henry, P.O. Box 333, Ormond Beach. Location of violation 33 Cypress Circle, Ormond Beach. No building permit issued as stated in the Land Development Code, Chapter 2, Article 3, Section 250, storage containers placed on the property without a permit. Third case is case number 22-112-247, parcel 422302060130. Michael Henry and Katherine Henry, P.O. Box 333, Ormond Beach. Location 33 Cypress Circle, Ormond Beach, Florida. Violation, no building permit issued in the Land Development Code, Section 114.6A1, pavers installed without obtaining a permit. The respondent, Katherine Henry, is requesting the special magistrate to hear arguments that the city does not have the authority to proceed with this hearing. So I will allow you to do that now. What will you be doing? Submitting cases to me?
No, the statute I already submitted to you, Your Honor.
Okay, all right, I've read that. And then the city can respond to you. Pertaining to what happens there, then we'll proceed. Okay.
Yes, Your Honor. Aside from the other legal issues that would be more relevant to talk about in the regular context of probably after the city has presented any evidence or arguments that they would like to present, the issue of this hearing starting and being set for a hearing is in violation of Florida Statute 70.45. Looks like I have a typo. It's supposed to be 45, not 445.
Say that again.
I just realized there's a typo at the beginning of my documentation I submitted to you. It's Florida Statute 70.45, not 70.445.
Yeah, okay, I see that in here.
So I apologize for that. So the issue here is that with that statute, I mean, there's tons of Florida statutes that talk about why the proceedings in this manner shouldn't be going forward. And why our protections as homeowners are of the utmost concern with the legislature and how they have set out the Land Development Code and all the other related statutes. 70.45 specifically created a situation where if a homeowner, such as myself or the two of us, my husband and myself, think that the city is violating our rights as property owners, then we can file a written notice of proposed litigation or proposed action to the city, where they are legally required by the statute. They must respond in writing with one of two things. They either have to respond in writing saying, we have decided that it's in the interest of justice, that we're not going to pursue the case, and so we will take no further action in this matter. Or they have to respond in writing saying exactly what harm it is that our proposed use of our property has caused, and how their proposed regulation of our property is proportionate to the harm that we're causing. There is no harm that our property is causing or our proposed use is causing, nor has it ever been alleged, because it's simply not the case. But instead of responding in writing as they are legally required to do, they instead instituted these proceedings and acted as though that statute didn't exist. They're cherry picking which laws that they're going to follow. And this is literally the statute 70.45. This type of hearing is precisely the municipal regulation that the state legislature says you have to put pause on what you're doing and provide this written response before you do anything else. And that way, if they respond in writing to me saying, oh, well, we think we have reason to do this because your 3 proposed uses cause harm in some way, and here's how they cause harm, etc., then I have the opportunity to, among other things, file a lawsuit against the city to stop them from pursuing this. But they did not afford me that opportunity and because there's not a specific deadline, I've been patiently waiting for the city to file their statutorily required response to me. So it would be premature for me to have filed a civil lawsuit against the city at this point. So this is really the only thing that can happen at this hearing, is that they be ordered to follow the Florida statute and file that written response to me, which, depending on what the response comes out to be, then I have the opportunity to follow the statute and file a civil case in the county circuit court. Otherwise, this hearing would be premature, and it would literally subvert the entire purpose of Florida Statute 70.45.
Can you refer me to sections in 7045 that you think are pertinent?
Sure. Give me a second, Your Honor. I must have already pulled it out.
That's okay.
Um, 70.45, I mean, really, the whole statute, it's not very long. The whole statute is relevant, so I'm not sure exactly how to best answer your question.
Okay.
But it starts with the definitions section, and this kind of thing would be a prohibited exaction, which is any condition imposed by a government entity on a property owner's proposed use of real property that lacks an essential nexus to a legitimate public purpose and is not roughly proportionate to the impacts of the proposed use that the government entity seeks to avoid, minimize, or mitigate. Obviously, attorneys wrote that because it's horribly complex, but that is what we're talking about, is prohibited exaction. And sorry, that was subdivision 1D. Subdivision 2, in addition to other remedies available in law or equity, a property owner may bring an action in a court of competent jurisdiction under this section to declare a prohibited exaction invalid and recover damages by a prohibited exaction. And it says that at least, this is subdivision 3, Your Honor, at least 90 days before filing under an action under this section, but no later than 180 days after the imposition of the prohibited exaction, the property owner shall provide to the relevant government entity written notice of the proposed action, which is what I did on November 8th, 2022. This written notice shall identify the exaction that the property owner believes is prohibited, which I did. It's the 3 regulations we're talking about here today. Explain why the property owner believes the exaction is prohibited, which I did, and provide an estimate of the damages, which was attached. The government entity shall review the notice of claim, shall obviously is a requirement, and respond in writing to the property owner by identifying the basis for the exaction and explaining why the government entity maintains that the exaction is proportionate to the harm caused by my proposed use of my real property, or by proposing to remove all or a portion of the exaction, or in other words, dismissing the action against me. And even if, in the event that they wrote back and said, oh, well, sure, this is the harm that you've caused, and this is how our exaction or regulation of your property is, we believe, is proportionate to your loss of use of your own property. Even then, if I decide to then file that civil lawsuit against the city, the government, the city entity, has the burden of proving even in that action that the challenged exaction or the regulations that they've brought up here has an essential nexus to a legitimate public purpose and is roughly proportionate to the impacts that our supposed, our proposed use of our property, that they're trying to, the harms that our property is supposedly going to cause. And that's, I guess, something that's telling is that it's the government entity that bears the burden of proof in that sense. And the whole thing is, that goes to the point of 70.45 is written for a reason. We can't cherry pick which laws we're going to follow, which has been a problem in this case all along. But this one stops this proceeding from even taking place. So they have to respond in writing either way, and the statute is written so that if they respond saying, oh, we think we're legitimate in our, we're going to continue with this, then they have to lay out what harm I'm causing and why they think the regulation is proportionate to my loss of use of my property. And then I get to be able to file a civil lawsuit against them where they have the burden of proving that those conditions exist. So it's, are all of our statutes complex and complicated and found in way too many portions of Florida statute chapters? Absolutely, but that doesn't mean that we get to cherry pick which ones we're going to follow, and I followed this statute to the letter, and I would expect that the city has to do the same, Your Honor.
Okay, that's interesting, and I appreciate that. You're an attorney, so...
Not a Florida attorney.
You're not a Florida attorney. Anyway, do you know what a judge would ask you? Do you know of any district court cases in Florida or Supreme Court cases that I could look at pertaining to this argument that you're making?
This specific statute, or no, because I think that's not our job. When it comes to implementing the statutes, we have to implement them on their face. We can't simply ignore them. And that's the thing, is that when this has been brought up to the city for almost 4 months now, 4 months, never once have I received a response either that they thought the statute was not appropriate, or I've received literally zero response on this at all. The only response I ever got was when they were serving me with the notice to be here.
Okay. All right, thank you. Is there a response from the city?
Yes, Your Honor. I haven't had an opportunity to review the full statute that she's mentioning, but it appears that this is the wrong forum to be arguing the application of this statute. That would be before the circuit court. This is not new legislation for the local government. This is not something that was created and now is affecting her rights. I believe she has lived in Ormond Beach no more than 2 years at this property. These ordinances have been in effect long before this. All these codes have been followed forward. So she moved here with full knowledge, and she has not gone to circuit court to challenge these ordinances or code. in the city. So I don't think she's in the right forum. There's no standing for this.
You want to respond to that?
Yes, absolutely, Your Honor. The problem is, I wouldn't have standing to have filed a lawsuit against the city before this because there wasn't a government exaction under this very statute where they were attempting to do what they're doing right here. It would have been kicked out because it would have been premature. The only way that, I mean, it's pretty clear. And not having time to read the statute, it literally takes up one page, and they've had notice of this for 4 months. But this statute is pretty clear. It's not challenging necessarily a particular statute that it's, you know, unconstitutional on its face. Maybe it's unconstitutional as applied. I mean, there could be all kinds of reasons why the proposed exaction is not appropriate under the statute. But that's not what the purpose of that statute is. And the statute doesn't mean that I have to then go and bear the burden of proving that a particular code is unconstitutional, either as applied or on its face. That's not the purpose of that statute. In fact, the statute is pretty clear that this, when they're trying to do this very thing, when they're trying to stop, I mean, look at what I was just served this morning, their proposal for if you should find in their favor what they're asking you to do, and just like the case right before us, they're asking that you issue the per day fines, and that you allow them at as of April 10th to go in onto my property, removing my property. That's the epitome of, it makes no sense to say we have to go through all of this before I would then go and file a lawsuit. In fact, I have to file the written notice to them of the proposed litigation prior to going and filing the actual documentation in circuit court. Otherwise, they'd kick me out. They'd say, well, you didn't comply with the requirements. I did exactly what I was supposed to do, and the city, because they have absolutely no experience or know-how in dealing with 70.45, decided that they're just not going to touch it. They're just not going to deal with it. But that's not how this works. We have to uphold all the statutes.
Okay, so your argument is in the nature of a motion to dismiss this action. Is that correct?
Yes, Your Honor.
All right, anything else from the city or from you arguing in this case? And a lot of the things which you have talked about are in your response, which I thoroughly looked through.
I guess just to clarify, Your Honor, the only thing I would say that I would be asking then in terms of looking at it as a motion to dismiss is that it be coupled with the city still has to respond one way or another in writing to this notice that I have served them. So I would ask not only that this action be, all three of these actions be dismissed today, but that they actually be required to submit the legally, statutorily required written response.
Okay, thank you. All right. After reviewing your written response and after hearing arguments, after hearing from the city of Ormond Beach, I find that your arguments are without merit, and I deny your motion. And I'll proceed now with the testimony of the city of Ormond Beach. So who is going to testify?
Your Honor, I'm going to object to the pictures that are up there already, though, because those were obtained illegally when the city went on my property without a warrant and took pictures. So
Okay,
they shouldn't be used in this
it's
proceeding.
It's denied. May proceed.
Good morning. My name is Janet Bruce, Neighborhood Improvement Officer for the City of Ormond Beach. The case before you.
You know what? You're gonna have to speak. I'm not hearing. Can you move close?
Can you hear me?
I sometimes like the two seats over here. But
My name is Janet Bruce, Neighborhood Improvement Officer for the City of Ormond Beach. The case before you is case number 22-112237. The respondent is Michael Henry and Katherine Henry. The violation address is 33 Cypress Circle. The violation of Land Development Code, Chapter 2, Article 3, Section 2 through 50, N1A, fence installed without a permit. I would like to submit into evidence a copy of the notice of hearing and a $100 citation with proof of good service, a
copy of the notice of violation with proof of good service, affidavits for regular mail and posting, copy of property appraiser's record, a copy of the land development code that is at issue in this case.
Any objection? Will it be admitted?
Yes, Your Honor. What I was actually trying to do is figure out which, I would have been a little bit better prepared had I been handed this
I
before.
believe we're talking in the case number 1, the 22-112-237, correct?
And there's two, I was handed two different packets that were stapled. My question is, are both of those being presented right now, or just the first one?
Just,
I wanted just the first one to be,
just
just the first one.
Okay,
the photos have not been submitted yet.
okay. Yes, sorry, give me just 1 second. I don't think I have. Was this, the sheet with the costs, that's not in that one? Okay, no, I don't have any of them.
She is presenting her case as to number 1, why she feels as a city representative that the building permit fence installed without obtaining a permit. And so that's the only one she's dealing with right now as far as.
Yeah, that one case has two packets that I had been handed before the hearing, but I realized that the issues that I had that I'm objecting to are mostly in the second packet, so what you've been handed so far, I do not object to.
Okay. Admitted into evidence as a composite. City's exhibit number 1.
I would also like to submit photos which led to the issuance of the notice of violation and citation, photos of the last status of the property which reflect the current state of the property, as well as the case cost sheet and the recommendation page.
So you are asking the magistrate to admit into evidence the beginning of the construction of the fences there, and then a date showing the fence has been constructed.
Yes, sir.
And that fence is still there, correct?
Yes.
Okay, I want to take a look at these. See what. Any objections won't be admitted?
Yes, Your Honor. I have a few different objections. My first.
No, I'm asking the objection for this particular composite right now.
Yes, and I have 3 different objections to this composite.
What are the objections to this being admitted?
The first objection I have is that these photos, at least in part, were taken when she went onto my property illegally without a warrant and took photos. Some of them were taken from across the street, but some of them were taken from being on private property, both mine and a neighbor's, without a warrant, and even squeezing in between vehicles that we had to go further back into our property, and to take photos that would otherwise, essentially, I guess, be fruit of a poisonous tree that she could not have done. Even law enforcement wouldn't have had a right to take those photos because there was no warrant.
So you want to respond to that?
Yeah, Janet, were any of those pictures taken, were they all off property?
Yes, ma'am. I was standing on the sidewalk.
Your Honor,
Wait till I.
sorry.
Yes, Your Honor, I just want to clarify that none of those were taken while she was on the
I
property.
was standing on the sidewalk.
Okay, you can respond.
See, this is why it would have been nice if I had due process and was given this ahead of time, because I have video footage, which I alluded to in the documents, in the notice of proposed litigation. They received this 4 months ago, knowing that I have video footage of her being on our property. In fact, you could see, just to give you an example, is it on a different? I know, just a minute. I have, yeah, the one photo that shows from the, that the photo itself shows that she was on our property isn't part of this packet, but I have video evidence. I have video evidence that shows that she was on our property and on the neighbor's property to collect these. I don't believe that, I'm not sure if it was the gentleman next to her or whoever was with her that day. I don't believe he was, but the video footage certainly shows that she was on our property and even walking between our vehicles to take pictures that day. And I did put them on notice. They've had 4 whole months, and I didn't have the photos to know what it is they're going to try to claim as evidence later as fruit of that poisonous tree.
Okay. Of course, your argument is still going back to the motion to dismiss this action that you made, which I have already denied.
No, that's a separate motion, Your Honor. I mean, that's a distinct...
So the, it is submitted as City Exhibit 2 as a composite.
Oh, Your Honor, I had 2 more issues with what was in there.
Okay, what are they?
Also, as part of this, Florida Statute 162.07 subdivision 3 says, although the formal rules of evidence shall not apply, fundamental due process shall be observed and shall govern the proceedings. Again, I wasn't given an opportunity to know that they were going to try to use these photos so that I could have brought to you my video footage to show you how she was physically on the property violating my rights in taking these photos. But also, when it comes to the recommendation here and the fact that they're going to be, you know, they're asking you to, in the end, if we don't remove our own property, for them to be able to come onto our property and remove that there's no reason why that information wasn't submitted to me earlier either. And again, the statute clearly requires fundamental due process. There's no reason why I was denied due process in knowing what they were asking for. And in addition to that, although she hasn't talked about the costs yet, the costs included in the sheet that she has that you would later have more discussion and rely on, I would object to because it's the same for all 3. So they're tripling up. So let's say you decide you're going to award costs on this one file. The costs would not be this. They can't be then awarded on the next 2 cases because there were not 9 certified letters sent to me. I don't know if that makes sense.
Okay, City, you want to respond?
I think we can just get to the cost matter later when we do the costs, and Janet can explain that those are treated as individual cases, and so they aren't just an overlap.
The magistrate's going to enter in the City's exhibit as a composite. All right, you may proceed.
I'd like to present the photos that are an issue with this case. This is the initial photo that I took on 9/1/22. They were in the process of building the fence. This was taken on September 2nd, 2022. I did issue a stop work order for all 3 cases that are at issue here on September 2nd, 2022. This is September 13th, 2022. After the stop work order was issued, they continued to attempt to finish the fence without a permit. That's September 13th, 2022. And this is the most recent photo taken on February 21st, 2023. The fence has been completed without a permit from the City of Ormond Beach.
Other than the fact that they did not obtain a permit, what's wrong with the fence? Anything?
The orientation is incorrect.
I can't hear you.
The orientation of the fence is incorrect. The fence is built backwards.
The what? Tell me again.
The fence has been constructed backwards. The good side is on the inside rather than the outside.
Okay, do you have any other documents to be presented into evidence in this case?
Not for this case, Your Honor.
Your Honor, if I may also just clarify, because no permit was applied for. There's no way that the city really knows without going onto the property if it's also the proper height and if it meets setback requirements.
What is your recommendation in this one case?
I recommend finding that a violation of the Land Development Code, Chapter 2, Article 3, Section 2-50N1A exists, and that the respondents be ordered to pay the $100 citation as well as the associated case costs and shall comply with the code by March 27, 2023. Compliance shall be achieved by obtaining an approved fence permit and pass a final inspection or to remove the fence from the property. Absent compliance, I recommend a $25 per day fine be imposed beginning on March 28, 2023, and shall continue to accrue until compliance has been achieved. Further, the respondent shall be obligated to contact the City of Ormond Beach Neighborhood Improvement Division to schedule a reinspection of the property to confirm compliance and date thereof. Absent compliance, I request that the city be granted the authority to enter onto the property on or after April 10, 2023, and have the right to remove the unpermitted fence from the property with all costs thereof to be assessed against the respondent. In addition, should the city remove and dispose of the aforementioned fence, the city shall not be responsible for any damage or loss associated with said removal. You want me to go to case costs or?
Case cost?
Yes. The current case cost on this case is $23.56. This is the breakdown. Each case is issued its own individual certified letters. They are not sent together in one packet. They're all sent individually as their own case. So,
Okay, now that's the city's recommendation. Do you want to make arguments to that?
I do. I also have, yes, Your Honor. With regard to the stop work order, there was no stop work order legally issued. When she spoke with me on the phone that very day that she's claiming that she put those out there, she mentioned nothing about a stop work order being issued. She ended up emailing me some information later that day. Again, she mentioned nothing, gave me no copies of any kind of stop work order via that email, it wasn't until later that I found out that although she knew I was home, my car has my name on it, it's right by the front door, and she had just spoken with me on the phone and she knew I was home, she decided to come out and put the signage in the boulevard of the property, not on our property and not even facing our property. So only the neighbors had notice, not us. And she put it up in a way where I want to say there was only like one staple on the thing. We had a really bad rainstorm later that day. So before I even saw that there was a post in the yard, the sheet had fallen off and we didn't find it until much later. And then that made sense as to why we had a random stake in the yard. So that would not constitute any kind of providing us notice or any kind of fair play, if you will, in any of this at all. There's no reason not to have simply knocked on the door and handed it to me or taped it to my front door or anything, anywhere on the front porch. None of that happened, let alone, like I said, in the phone call or the email was anything mentioned about that at all. But there's a bigger issue, and that is the cherry picking that's happening. It's a definite equal protection violation. We did move here fairly recently, still getting to know our neighborhood and the city of Ormond Beach in general. And so as we've been walking through the neighborhood, just being able to see with our own eyes, in an area that's just, I would say, our immediate neighborhood, just barely over a quarter mile square, there are numerous examples of fence violations, In fact, there are
Is
6.
that what this part is?
Part of that is, yes. The color-coded spreadsheet, my printer doesn't print color, so I don't remember what the color was. Mine's gray. But there is, at the beginning, the first column separates out just general permits not having been issued for extensive remodels, that I think is navy and blue. And then there's a section on pavers and a section on fence. It's specifically about the fence that I'd be talking about.
How did you determine your cherry picking chart? Did you go through the neighborhoods and look to see where you thought there might be violations, but nothing had happened there? I'm just curious about.
Yeah, it's just something that, as I regularly walk my neighborhood, and it's as this situation arose, and I read the entire code, I looked around and I'm like, this doesn't seem right, because we've seen all of this. And so I decided to give them just a few examples in the notice that I sent them in November. But since then, it's kind of one of those things, you know, when you first buy your first white Toyota Camry or whatever, and then you all of a sudden everywhere you go you see white Toyota Camrys you never really noticed before. It's that kind of situation, Your Honor. So as we walked our neighborhood, this isn't me, you know, hanging out in the backyards of my neighbors or anything like that. This is what you can visibly see of violations happening. What is that? Okay, sorry, just want to make sure. These are ones that you can visibly see, but there are just within that quarter square mile, which we're talking about is less than 1%. It's 0.7% of the city of Ormond Beach. We're talking about 63 other documented examples that I'm able to just see of issues where the fence, land development code as it pertains to the fence, are being ignored.
So you did a very good job here, but how would you specifically know that there was not a permit or there wasn't a variance in a particular property where you thought there might be
Because
violations?
those records are online.
Uh-huh.
And some of the issues...
That's the way you looked at them?
The records are online, yes, but when it comes to, we're talking about the wrong height or opacity, those are things that you can see. I mean, as far as variance, none of those appeared, but dilapidated fences, I couldn't imagine that there would be a variance for a dilapidated fence. But at any rate, and obviously when I put my initial document together, we hadn't had the second hurricane yet, and we live beachside. So the amount of violations would actually be staggering, but it was too impossible to keep up with all of that because my neighbors, literally every single neighbor around me, even Pizza Hut on A1A, everybody had at least a portion of their fence that had come off, if not had a total decimation of their fence. And quite a few of those neighbors have already been putting them together, which total more than 50% of the lineal footage of that fence, which triggers the permit needing to be required. And this isn't just neighbors. This is, and like I said, these 63 examples, that's in less than 1% of the entire square footage of our city. But these very types of fence violations are also found at 39 Byron Eleanor, where a city work van, it must be a city employee, lives there and parks the work van there every day. There's, and that's already been in your packet. Ormond Beach PD regularly parks at 52 Byron Eleanor, which has had, since the hurricanes, their fence was totally torn down, which I have pictures of that, and submitted that in there to you. And they have a whole new fence, and there's no permit for that. And the city knew about a lot of those violations because there were 4 other permits that were pulled in 2022 for various other things on that property, not to mention that there's a Ormond Beach an Ormond Beach officer that regularly parks at that property, but also several of these other instances. So it's it's absurd to me that we can cherry pick and go, well, Ormond Beach PD is going to get a pass. Ormond Beach city employees can get a pass. Ormond Beach, whatever government officials that I have in the example for you can get a pass. Or 63 other examples just that I've documented of fence violations alone, they all get a pass. And not to mention when you multiply that by the 0.7%, I mean the numbers are staggering. and how that doesn't demonstrate an equal protection violation when I am 100% unequivocally guaranteed equal protection under the law,
Okay,
I wouldn't know
let
what
me
it is.
stop you 1 minute about your argument on the cherry picking. You've done a lot of work on it, I can tell. I've been the magistrate here for 18 years. Before that, I was a judge for another 20 years in Volusia County. And almost every other time I come here, someone will say, you're treating me like you're not treating this person. There are other violations that go on, and you should not be doing things to me because you're not doing things to these other people. So I say to them, can you refer me to a case that went up to the district court or the circuit court, something to say that this argument of cherry picking is substantiated? And I haven't got very much, to tell you the truth. I have to comb my mind into this particular one. Now, if you don't win in this case and you appeal it to the circuit court and they substantiate that argument of cherry picking, I would be most interested to know about it. Is your argument for this particular one going to be the same in the other two?
Some.
Yeah.
As far as, I don't know if I'm cutting you off, Your Honor. I had other things to say about the fence issue besides the equal protection issue.
Okay, well, you understand that I'm not buying the cherry picking argument.
I still have a right to place it on the record because
You do have a right, but I have a right to continue with my hearing, and when I think I've heard all that I want to hear on a particular item, I can tell you that to go on to something else. So let's go on to another argument that you
Well, yes, Your Honor, that's what I was just about to do. When it comes to the costs, I don't know why mine looked different, but mine looks like that you now are seeing in front of you. I do acknowledge that they send the certified letters in a separate envelope for each of the three. But we were, first of all, I shouldn't have to, there were three, there's a hearing today, right? We have a hearing, there are 3 cases, that would be 3 certified letters. But you could see there's 3 listed just for that one alone, plus another copy sent by regular mail, which I don't know why that would be a cost to me. But the other cases as well, there's an exact same sheet. So in the end, they want to charge me for receiving 9 certified letters. There were not 9 certified letters sent. There's 1 for each case.
Well, they have a procedure which they have to put cost on each case.
Oh, I get
However,
that.
When it comes to me, I can decide what I want to do as far as whether I want to order the cost or not. So
I'm just saying, if as far as certified mail goes,
Yeah.
it shouldn't be 3 on the screen we're looking at. It would be 1. And the regular mail, I don't know why you would send regular mail when it's already sent by certified mail.
okay, I understand your argument.
That's all I have, Your Honor.
Okay, so I'm going to wait till we do all 3 before I make my findings and determinations. So let's go to the